I'm Brittany Lewis with Forbes Breaking News. Senator Sheldon Whitehouse blasted dark money influence on the Supreme Court at Tuesday's Senate Judiciary Committee hearing. The senator claimed the court is dominated by the Federalist Society. His criticisms follow a series of Senate floor speeches called, quote, "The Scheme," in which Whitehouse details how dark money groups have led to a right-leaning court. Whitehouse argued for ethics and recusal reform on the court and responded angrily at the leaked decision to overturn Roe v. Wade. Let's listen in to the Rhode Island Democrat.
Putting documents into the record, we have a letter from Director Gabe Roth, the Executive Director of Fix the Court, in support of the reforms we're going to discuss today. We have a letter from the Project on Government Oversight. Similarly, we have a letter from the Governance Institute within the Brookings Institution. We have a letter from a considerable number of scholars to Justice Roberts, urging the court to complete and adopt a code of conduct for the Supreme Court of the United States. We have a piece from Nina Totenberg, who is a well-regarded chronicler of Supreme Court activities, regarding the recusal issues arising out of the January 6th related decisions. We have Jane Mayer's terrific piece in the New Yorker on the same issue, which has many statements by legal scholars. We have an article about the Supreme Court battle between Google and Oracle, and the discovery that Oracle and Google were both funding dark money groups to file amicus briefs for them without telling the court. In this case, I think this is mostly about the Oracle effort. And then we have an article from In These Times about the backdrop to the Janus case, which, as many of us know, began with Abood and then had an intermediary decision in which Justice Alito expressed his displeasure with all the related precedent and his desire to overturn it, which then prompted a big rush from dark money groups to get in front of the court to do exactly that in the Friedrichs case, which then failed because Justice Scalia died and they lost the 5-4 Federalist Society majority. But as soon as Justice Gorsuch was appointed, everybody showed up. There was some repositioning with different front groups taking different roles. But then the Janus decision came down and the mission was accomplished. So I add that article to the record. So those are all the public documents that I wanted to put into the record. Then there's some correspondence that comes from, mostly from me, and addresses various different issues. The first letter that I'd like to put into the record comes from me and Hank Johnson, the chairman of the equivalent committee over in the House Judiciary, and it consists of a letter from me and him to Justice Roberts and Clerk of the Court Scott Harris, dated May 13, 2020, to ask them to address the amicus problem. The reply to that came September 18th from the Clerk of Court, and we have that letter. The issue then went to the Judicial Conference, and along with Chairman Johnson, I wrote a lengthy letter to the chair of the Judicial Conference, again regarding the disclosure requirements for amicus briefs. In response to that, the U.S. Chamber of Commerce wrote a letter to the chair of the Advisory Committee on Appellate Rules, and that was on October 6th, and then on November 10th, Chairman Johnson and I replied to that letter. So I would ask that that's all one back and forth exchange of related correspondence. The next topic that we addressed has to do with recusal and conflicts of interest. And we have a letter that a number of senators, including myself, led by Senator Warren, wrote to Chief Justice Roberts and Justice Thomas. We also have a related letter that Chairman Johnson and I wrote to Chief Justice Roberts. We have a letter that I and Senator Blumenthal and Chairman Johnson all wrote to Justice Barrett and Clerk Harris related to recusal, in that case in the Americans for Prosperity Foundation case. So that's another packet of communication back and forth between us and the court related to one of the issues that comes up today. And then finally, on the question of travel and hospitality and what is real personal hospitality and why hospitality from people that justices have never met, provided in commercial settings, appears to qualify in their view as personal hospitality that doesn't need to be declared. This begins with a February 4th letter to Justice Roberts and Clerk Harris from me and Lindsey Graham. And then on July 12th, Lindsey and I, Senator Graham and I, got our reply from Ethan Torrey, the legal counsel to the court. So we have that. In the wake of that, I wrote to all of the circuit courts of appeal, asking them for their view on, in their courts, whether they would accept their judges getting undisclosed free vacations from people they'd never met in commercial resorts and failing to disclose it. That was on August 30th. Got no answer to that. So I renewed the request on April 18th with another letter, this time joined by Chairman Johnson. And then we got this letter April 29th, 2022, just on the eve of this hearing, after months of delay, actually conceding, this is a letter from the Administrative Office of the United States Courts, conceding that these were actually legit questions and that they would look into getting us legit answers, which is rather a different point of view than the original blow-off that we got from the Supreme Court. So this makes twice that persistent questioning from this committee has resulted in work within the judiciary to try to solve these problems. The first was on the amicus issue, which the court initially pretended wasn't real and now is being considered within the Judicial Conference by a special committee. And then now this concern of freebie vacations cranked up with people that the justices don't know at commercial resorts that go unreported. And while the Supreme Court has not expressed much interest in that, the combined pressure of the circuit courts of appeal appears to have started a process. So baby steps, but good steps, and I ask unanimous consent that that whole slew of articles and letters and this series of my correspondence be made a part of the record of this proceeding, and it will be without objection. I see that Chairman Durbin is here, so what I would like to do, because he's the chairman of the full committee, is make a brief opening statement myself, turn to Senator, which way? Kennedy, to do his opening statement, and then turn to Senator Durbin for his opening statement. And I'll first veer from my prepared opening statement to report that today is a hell of a day to be considering ethics questions around the Supreme Court, and particularly the spectacular level of right-wing influence that seems to be the tendency of the Supreme Court since the Federalist Society has taken control of Republican judicial nominations. We do not know yet whether Justice Alito's leaked decision is going to be the decision of the court or not. But as of the moment of this hearing, there has been no disavowal by anyone. So it appears that this precedent is being thrown into the bin, like so many other precedents that displease the right-wing donor base that had such an important role in getting these justices on the court. And of course, the overlay between that problem of right-wing donor influence on the court and the dark money morass that surrounds it has a pretty significant overlay with the ethics questions that we will address here, and which have caused the American public to have a growing and increasingly warranted perception that special interests have taken undue control over our courts. We all know that courts derive their power from public confidence. They don't have armies, they don't have budgets, and we trust judges with the judicial power in the faith that they will not abuse it, that they will treat people fairly and decide matters impartially, not to preconceived ends pressed on them by special interests. Well, it's not going well. In its most recent poll on the subject, Gallup registered the Supreme Court's lowest approval rating ever, a collapse of confidence that coincides with failures of transparency and accountability at the court, conspicuous failures in the areas of gifts and hospitality disclosure, recusal, and identification of amici curiae. The fact that so many justices were selected and their confirmations campaigned for by dark money organizations exacerbates the danger. And the win rate of certain political interests in partisan decisions defies statistical explanation. My counterpart in the House, Representative Hank Johnson, Senator Blumenthal, and I introduced the 21st Century Courts Act last month. It will close loopholes and make sure that the judiciary's ethics rules meet the same standards as Congress and the executive branch. The 21st Century Courts Act is the culmination of work that our offices have done over many years. Our concern takes on new urgency in light of a recent incident that accelerated the public's loss of confidence. Last month, we learned of a Supreme Court justice's failure to recuse himself in a matter where his wife had texted with Donald Trump's chief of staff about strategies to overturn the presidential election. A congressional committee investigating the January 6 attack on our Capitol requested records of communications with the Trump White House. Donald Trump sued to block those records from being turned over, and he asked the Supreme Court to review the challenge. The committee's inquiry could have revealed the justice's wife's texts, yet he failed to recuse himself. This was not an isolated recusal problem. Last April, 3 Supreme Court justices refused to recuse themselves in a case brought by the organizational alter ego of a group that had spent millions of dollars to get the 3 justices confirmed, a group that called one of its efforts a, quote, full-scale campaign to get the justice confirmed. Caperton v. Massey acknowledges that these kinds of campaigns can create at least the appearance of bias, but not only did the justices not recuse, none even deigned to explain. It's not just these recusal examples that are the problem. The court's practice under its personal hospitality rules is peculiar and problematic. Last August, I asked for that explanation from all the circuit courts of their interpretation of the personal hospitality exemption and whether it aligned with what the Supreme Court was telling us. It took the administrative office until last Friday to respond and to admit that no clear guidance exists for the courts on these questions, in contrast to the rules that govern Congress and the executive branch. Amicus groups show up in orchestrated flotillas without disclosing who is behind them, and they enjoy a statistically peculiar rate of success in getting their way at the court. The Judicial Conference is actually at work on amicus transparency to, as one judge said, identify the, quote, power behind the throne of these front group amicus filings. An overarching problem is that on these ethics questions, each justice is judge in his or her own cause, without review, transparency, or accountability, and with no place where complaints can go to be addressed. Awkward ethics questions can simply be ignored. One example makes this problem undeniably clear. Actual, ongoing ethics investigations into Judge Kavanaugh were dropped when he became Justice Kavanaugh simply because his ascension to the Supreme Court set him beyond the reach of the ethics rules and procedures applicable to all other federal judges under which he was being investigated. The highest court has the lowest standards, indeed only the standards which each justice, in his or her own unreviewable caprice, chooses to impose on themselves. The bigger thing we could do is likely to pass my Disclose Act, which would make transparent the big money, the big dark money in particular, now being spent anonymously to get justices confirmed. It seems to me essential when someone is spending millions of dollars on judicial confirmations to influence the makeup of the court to understand what business they may have before the court. The court's reluctance to treat any of these issues seriously puts us in the position of having to act legislatively. To be clear, we need to root out problems with our judiciary's ethics practices so that we can protect the public's trust in our federal courts. We need to update the laws and practices regarding recusal. We need safeguards to protect against the dark money influence that now enmires the federal judiciary. We need rules for disclosure of who is behind front group amici. And we need a binding code of conduct for the Supreme Court, the only court in the country that doesn't have one. Justices say they can handle these problems themselves. We may hear more of that today. But they've had plenty of time and plenty of cause, and they simply have not. So today we consider what Congress can do to address those ethics issues and to assure that the court's rules and practices merit the confidence and trust of the American people. And with that, let me turn to my distinguished ranking member, Senator Kennedy.